The Equal Protection Clause of the 14th Amendment has been interpreted to mean that state and federal laws cannot discriminate against groups of people. This principle, however, is not applied in the same way to all groups of people. Classification is a judicial creation. Through their decisions, the Supreme Court has created 3 classifications when judging whether a law violates the Equal Protection Clause of the 14th Amendment. On this slide, I introduce the 3 classifications. For the rest of the PowerPoint, I will go into more detail about how each is applied. Suspect classification is the most strict classification, and it applies to race. Quasi-suspect classification is in the middle, and it applies to women. Non-suspect classification is the least strict of all 3 categories, and this applies to age, wealth, and sexual orientation. The first time the Supreme Court alluded to the idea of suspect classification was in the court case Korematsu versus the United States of 1944. This is really where the Supreme Court decision where we get the idea of legal classification. The court case was about Japanese Americans being interned during World War II. The government was arguing that this was necessary because Japanese Americans living on American soil could conspire with Japan to attack us on our own soil. The court agreed with the national government. They said there was a compelling state interest, and therefore it was constitutional to relocate Japanese Americans to internment camps. The court case reads, all legal restrictions which curtail the civil rights of a single group are immediately suspect. You can see there we actually have the word suspect. That is not to say that all such restrictions are unconstitutional. It is to say that courts must subject them to the most rigid scrutiny. Pressing public necessity may sometimes justify the existence of such restrictions. Racial antagonism never can. So in this court case, the Supreme Court is saying there may be times where our government has to discriminate against certain groups for our own safety or other compelling government reasons. But it is unconstitutional, according to the 14th Amendment, to ever create a law just to antagonize a race. For each level of classification, there is a standard review that the Supreme Court has established must be proven by the government in order for the law to be declared constitutional. For suspect classification, the standard of review is called strict scrutiny. The question the court asks itself is there a compelling state interest in this classification? What this means is the government must prove that the discriminating law is essential to the safety and security of Americans. It is very unlikely that the Supreme Court will agree to any law that treats groups in this category differently. Honestly, today, the Supreme Court would probably rule different on the Korematsu case. America has since apologized to Japanese Americans and given money or reparations to people who had been interned. Many minority groups want to be in this category, such as homosexuals and women, because it would make them a much more protected group and they'd be less likely to face discrimination. At this point, however, this classification only applies to race. I'm going to talk about 2 Supreme Court cases in which strict scrutiny was used to declare laws unconstitutional. The first is Brown versus Board, a decision that you guys are very familiar with, which was made in 1954. In that case, the court said there was no compelling reason that segregation would help the state with education. Actually, that segregation would make it more difficult for states to educate children properly. The second case is Loving versus Virginia. In this case, the court struck down a state law that outlawed interracial marriage because, again, they can find no compelling state reason for making interracial marriage illegal. The next level of classification is called quasi-suspect. In quasi-suspect classification, the court uses an intermediate standard of review, asking the question, is there an important purpose for this classification? Is there a substantial relationship to an important state interest? It is easier for the government to prove an important purpose than a compelling state interest as required in suspect classification. Quasi-suspect classification applies to women. One Supreme Court case in which quasi-suspect classification applied was Rosker v. Goldberg of 1981. In this case, the court agreed with the law requiring men, but not women, to register for the draft. They said there was an important purpose for distinguishing between men and women because, I guess still now, but definitely at the time, they believed that men were stronger and more able and fit to serve in the military. One case in which justices used quasi-suspect classification to declare a law unconstitutional is Orr v. Orr of 1979. In this case, the court struck down a law requiring men, but not women, to pay alimony after divorce. The court could find no government purpose that was accomplished with this law. Before I move on to the next classification, I just want to point out that there's a big connection between these classifications and the lecture I'm going to do on Monday, which is why you're supposed to be listening to this before Monday's lecture happens. Many women have fought to achieve suspect classification, to move above quasi-suspect classification, to completely eliminate discrimination against them. Other women, however, agreeing in part to these physical differences like we see in Rosker versus Goldberg, but mainly because of their childbearing capability, want to remain in quasi-suspect classification. They see some advantage to women being allowed to have maternity leave, which might not be possible if you had to treat both genders identically. It could be the case in suspect classification. The final and lowest classification is non-suspect classification. This classification uses a standard of review of minimal rationality. The court asked itself, is there a rational basis for this classification? Does the government have a rational reason for making a law that treats a class of people differently? This is much easier for the government to prove than the quasi-suspect classification and strict scrutiny, which is in suspect classification. This classification applies to age, wealth, and sexual orientation. Hopefully, as you complete your outline and recording this week, you will notice that the LGBTQ community would like to achieve a higher status in order to protect themselves from discrimination, because being in non-suspect classification does not really afford them much protection. An example of a case in which the Supreme Court upheld a law using non-suspect classification is Gregory versus Ashcroft of 1991. In this case, the court upheld a law requiring Missouri public officials to retire at age 70, saying that this served a government purpose, making sure you don't have senile officials running the states. Another case, Romer versus Evans of 1996, the Supreme Court used non-suspect qualification to declare a law unconstitutional. In this case, actually an amendment. The court struck down a Colorado constitutional amendment that banned legislation to protect people's rights on the basis of sexual orientation. So this amendment basically said no township, no county, and the state itself could never make a law that said it was illegal to discriminate against people because of their sexual orientation. And the court struck this down because they could see no legitimate state goal behind the law.